Welcome to the Dealmaking with Laura Difrancesco podcast. I'm Laura Difrancesco, your host. We're talking all about mergers and acquisitions, buying and selling small businesses, as well as corporate law. We are taking our experience closing over $10 billion of transactions since founding Dean Street Law 5 years ago, and my experience being an M&A and corporate attorney for over a decade and making it accessible to you as an entrepreneur. I hope that this helps you in navigating the complex world of mergers and acquisitions. And also, we're always happy to be a resource for you here at Dean Street Law. You can always apply to work with us through our complimentary consultations linked in our show notes. And a huge shout out and thank you to everyone who's subscribed and left us a 5-star review. If you haven't yet, be sure to subscribe and also leave us a 5-star review. It's one of the best ways to support us as a small business. And also be sure to share with your friends and colleagues on social media, through text, email, or however is easiest. It means the world to us that you're supporting our content and helps us make more to support you in your journey. Welcome back to the latest episode of Dealmaking with Laura Difrancesco. I'm your host, Laura Difrancesco, and today we are here to talk about the legal documents needed to buy or sell a business. I'm excited to chat with you about it. We have closed over $10 billion of transactions here at Dean Street Law since our inception in 2019. In addition to that, we specialize in mergers and acquisitions, particularly buy side, sell side, working with investors on buying and selling businesses. And we're really excited to chat about this because when you're buying or selling a business, oftentimes there is a misconception that you just need a purchase agreement, or someone asks me, hey, can you just prepare a purchase agreement? I just need that to sell the business. When in fact, you cannot legally sell the business with just a purchase agreement alone. We're going to talk about what you typically see in an asset purchase versus stock purchase. They are different depending on that. A little bit more about me and my background. I'm an entrepreneur myself. I have more than 5 businesses, including Dean Street Law, Flourish Co-working and Event Space right behind us, Ethereal Farms, Laura Difrancesco LLC with Acquisition Insights, our course on the legal aspects of buying a business, our LOI Masterclass, Optimize Your Exit Masterclass for selling your business, as well as Entrepreneurship Through Acquisition, a legal guide to buying a business, buying a small business. This is the upcoming book that we have that we're launching. If you haven't checked it out yet, please be sure to download the first chapter. Sign up for the wait list. Let me know your thoughts. Would love to hear them. And I'm really excited to chat more about this topic. I actually have a copy of our template closing checklist and timeline for both an asset purchase and a stock purchase. These are available on our Acquisition Insights course and templates bundle if that's of interest to you. We utilize these to really communicate between the parties what's expected to be completed by what timeline in order for you to close on time. And so what we actually have this structure to do, and I haven't printed out everything because I wanted to be able to make sure this is legible. But we have, in addition to the transaction documents themselves, a whole Gantt chart with the transaction timeline, the target date for closing, and what stage different elements need to be completed in order to close on time. So I'm excited to chat more about these. Let's talk about why the legal documents matter. Ultimately, you would not necessarily buy full sticker MSRP on a brand new car and not get the title to the car. You would be expecting, well, I'm buying the car, I need title to the car. Absolutely the same in the transfer of the business. The challenge is that a car is just one type of legal asset. And when you have a company, you have many, many, many different types of legal assets. You have the computers, you have the lease, you have the employees, you have the intellectual property, the name. In a SaaS company, you have the code, the developers, right? There's so many different assets, manufacturing plant, equipment, leases that you have for equipment, loans, customer contracts, vendor contracts. These are all both assets and in some instances also liabilities of business. So when you want to transfer those, you have the different mechanisms for transferring a car with your title versus a piece of real estate with a deed versus a piece of personal property, such as your computer with a bill of sale. Those are 3 examples of dozens and dozens of different types of assets that a company owns. So you can either structure your business as an asset sale, in which case each different asset class has to be transferred according to the title and transfer of ownership of that type of asset. Cash is who has it in hand, right? It is control over the asset that ultimately determines the ownership of the asset. Whereas if you have a stock certificate, that's going to be certificated in your name. So each different type of asset has a different mechanism for ownership, control, and transfer. And then in addition to that, the ownership interests of the business itself, whether it's an LLC and its membership interests, or it's a corporation and its stock, each of those have different transfer mechanisms, approval requirements, and some of these different types of asset classes may also have approval requirements. Licenses, contracts, etc., may all have different approval requirements. So as you can see, we're trying to establish legal ownership of something requires legal documentation. So why do the legal documents matter? Because ultimately, if you have one document but not the right document, you don't actually own the business you think you bought. And I certainly never want you to spend $1 buying a business, buying an asset, thinking you own it when in fact you do not, especially when that dollar tends to be more like millions of dollars or tens of millions of dollars. You want to make sure that you've legally documented the transfer of the business. And in order to do that, you have to have a whole lot of more information about what different types of assets or restrictions on transfer that there are, and the governance documents and the contracts and the licensing regulations, all these things. We help you work through that so that when you think you're buying a business, you are actually buying a business. And not only do you think you're buying a business, but you can get it financed, because your lender will not finance a deal where they know that you're not legally documenting it properly. That's required for the underwriting approval process. They need to see all the legal documentation around transferring the business to make sure that there are no gaps or issues, everything's being addressed appropriately. And then in addition to that, that will both protect the buyer and the seller. The buyer thinks they're buying something. They need the legal documentation, both from a transfer of title to also the representations and warranties that the seller will provide, that this global collection of assets and liabilities is what the buyer thinks it is, that it's solvent, that it's able to pay its debts as they become due, that the financial statements are accurate, and there is no missing information that hasn't been provided, right? Those are just a couple of the representations and warranties you'll see, whereby essentially the seller will represent and warrant that the business is as it seems. The business is as you think the buyer it is. And then you have indemnifications to allocate risk, because ultimately, just like real estate, although most people don't think this, most people think real estate is simply a deed of ownership, when in fact, real estate is a bundle of rights and obligations. You have rights to develop subterranean, you have rights to develop the land, you have rights to develop in the air, you have water rights, you have development rights, and then you have bundles of those rights that you've sold off. So maybe there's an easement, there's an electrical easement, or there's a neighbor's easement. So just like real estate, how it's a complex bundle of rights and obligations, when you're thinking about, yes, the deed documents a piece of real estate, when in fact it is a collection of assets, liabilities, obligations, the same thing is true in a much, much more exponential manner with the sale of a business. The sale of the business is going to be a collection of rights and obligations in every different sector of the business, every different type of asset, every different contract, every organizational document, right? So this is why documentation becomes even more important not only to just legally transfer the business, but to also make sure that the business you think you're buying is the business you're buying. And then from a seller's perspective, making sure that the business you think you're selling is actually the business you're selling. Because imagine selling a business expecting everything to transfer, only to realize that you're holding the bag for some contracts that you really don't want to keep and you're not any longer getting the benefit of and don't want to be liable for. So that's clarity around documentation and avoiding disputes and delays. That's really important. If there's issues with the documentation, it will cause disputes, it will cause delays. Obviously, you want documentation that's fair to both parties, represents both parties well, but is also fair in the market and something that each party can stand behind and can negotiate well. So let's talk about the initial documents that you'll see in a transfer of the business. Typically, this is going to be your letter of intent. This is the foundational aspects of the terms of the sale. In addition, you'll also see the non-disclosure agreement before the seller provides any confidential information, tax returns. Hopefully they're redacted so they don't have social security numbers on them. Also financial statements. Before they provide any confidential information, you have to make sure that there is going to be confidentiality between the parties, and that's established through contracts such as a confidentiality agreement, also known as a non-disclosure agreement. Those are going to be early on. Typically, you'll even see an NDA signed before confidential materials are provided. So generally, that's even going to be before sometimes the buyer learns the name of the business. The name itself, the sale price are confidential. So oftentimes you might have a redacted teaser of a page that's going to say some high-level financial information, but not identify the name of the business. And then in order for the buyer to get a copy of more information about the business, some confidential information, including the name, the employees, maybe not even the name of the employees, just like the structure of the business, the structure of the revenue, the overall structure of the business, as well as financial statements, then in order to get that information, the buyer would need to sign a non-disclosure agreement. And you generally want this to be mutual between the parties, certainly to protect the seller's information, but it should also protect the buyer's information as well. And then your letter of intent, a lot of people think that it's non-binding. It's something that you just can throw together on your own without attorney review. It is binding. At least half of the provisions generally are binding. While you may have the purchase price and the deal specific terms that are non-binding, other terms such as the exclusivity provisions and the confidentiality, if that's included in the letter of intent, as well as governing law, various other elements. If there's a sharing of costs, sharing of legal costs, sharing of due diligence cost or liability for costs, that's oftentimes binding on the parties, as well as if there's a deposit, oftentimes those are binding on parties as well. So the LOI is a step that I recommend getting attorney reviewed. If not, having the attorney prepare and negotiate it. We do a flat rate for that, so that we're able to help our clients in that early stage. Next, once the deal is under LOI, and I will say just a little footnote, sometimes people also submit an indication of interest or an IOI before an LOI, whether it be buyer or the seller's requiring it to provide additional confidential information, or just if it's a very competitive situation and you want to kind of narrow down who you're negotiating with. An IOI might have a purchase price range. It's going to be generally more non-binding than binding. It's going to generally be less formal than an LOI, cover less things at a more high level, but it's going to be generally the higher economic components of the deal. So it can see whether the parties are even on the same page to continue negotiations. Oftentimes, unless you have a reason for it, you'll just move to an LOI, but I wanted to flag that for you. When it comes to navigating corporate law, entrepreneurship, and managing small businesses, experience matters. Dean Street Law is a boutique corporate firm specializing in mergers and acquisitions and additional focus in real estate, commercial transactions, finance, and corporate governance. With over $10 billion in deals closed, Dean Street Law has extensive experience representing hundreds of clients in thousands of transactions, from small businesses to Fortune 500 companies. Whether you need startup guidance or advice on closing multi-million or multi-billion-dollar deals, we're your trusted partner every step of the way. Visit deanstreetlaw.com in the show notes to schedule a complimentary consultation. Now, once you get the LOI signed, immediately the parties are going to go into due diligence. So before the parties even begin legally documenting the transfer, the parties need to exchange documents to share the existence of the business, what the business is comprised of, that bundle of rights and obligations, insurance policies, organizational documents, contracts, litigation history, loss runs, employment relationships, all of those things. So due diligence is where the seller will procure a lot of documents. Now, on sell side, we're working with the seller to help them answer due diligence requests, to help them understand what they need to procure, and we also help them prepare for that process as early as possible as well. With respect to the due diligence documents required, sometimes that's in a under $10 million deal, you might see anywhere from 150 to 800 plus documents required in the due diligence phase. So it's a very onerous phase, especially for the seller. Of course, we want to make sure as seller's counsel, we would be redacting sensitive information such as social security numbers, home addresses, etc. Not only because of the safety of information of those transferring to a buyer that ultimately may not close on the transaction, but also because in the technology world that we live in, that data can be leaked somehow, and we certainly don't want it to be leaked. We want to protect the confidentiality. That's why we put it in a data room. We don't send it via email. We make sure that data room's protected. We know exactly who's getting access to it. They have to provide their name. They have to provide their email. They're the only ones that can get access to it. So we certainly have a lot of confidentiality protections. With that said, you're still putting documents online, and we want to be very careful to make sure that sensitive information, should anything happen that's out of either party's control, that information does not contain sensitive materials and that it's redacted. Now, it's going to include tax returns, financial statements, licenses, permits, leases, supplier contracts, customer contracts, employment agreements, HR files, a lot of documents. Like I said, anywhere between 150 to 800 plus documents in an under $10 million deal is what you typically see. That's all part of the underwriting process. It's all very natural. With that said, we want to make sure that the requests from the buyer are reasonable. Normally on deals such as these in small business sales, the buyer is not requiring the seller to create documents that don't already exist. So for instance, if they're asking for certain manipulations of financial numbers, that is the obligation of the buyer to extract from financial data that the seller provides. That's generally how it goes. We want to be careful that the seller is not trying to create documents that it can't really substantiate. Maybe it's exporting different things from QuickBooks that they haven't exported. Sure, that's totally normal. But when it's talking about manipulating data and creating reports for the buyer, we want to be very careful of that, both on buy side and sell side, just because the sufficiency of that data, the test of that data, if it's not generally exported, if it's not generally manipulated or used, can be very difficult to discern. With that said, we'll work with your QOB provider, accountant to go through all of that. Thinking about buying a business? Unlock the secrets of successful acquisitions with Acquisition Insights, your legal roadmap for success. With over 81 modules of video lectures, written materials, guides, and checklists, we provide in-depth guidance to navigate every step of the process. From initial interest to closing the deal, get the expertise you need to make informed decisions. You can also access our battle-tested templates in the Acquisition Insights course and templates bundle, including our template LOIs, letters of intent, pre- and post-LOI due diligence request list, material deal terms lists, and more. Visit lauradifrancesco.co/the-shop today and take the first step towards buying your dream business. All the links are in the show notes. Now, when you're thinking about the legal documents required for a asset purchase versus stock purchase, let's get into the bulk of that. So I'm going to call it a stock purchase or equity purchase. But really, if it's a corporation, it's a stock purchase. If it's an LLC, it's a membership interest purchase. So in that purchase agreement, that's going to be number one. So let's go through the closing checklists. We have a different closing checklist for an asset purchase versus a stock purchase or an equity purchase, because in an asset purchase, you have to transfer each of the different asset classes legally in a different manner. Whereas in an equity purchase, it's simply the ownership interests of the business itself. So actually, even from a fundamental perspective of who the seller is, changes in an asset purchase versus an equity purchase. In an asset purchase, the seller is the company itself. In an equity purchase, the seller is the actual owners of the company. So those are fundamental changes that you'll see. When we're going through the due diligence process, that's generally the buyer is going to circulate a due diligence request list, and then the seller will produce the due diligence documents responding to that request list, as we discussed. The next item is the purchase agreement. In an asset purchase, that'll be your asset purchase agreement. In equity purchase, that'll be your stock purchase agreement or membership interest purchase agreement, something of that nature. There are also mergers, but they're so rare in small business sales that we'll skip over those. And then you'll generally have the buyer's drafting, but it's honestly up to the parties. If the seller has engaged M&A counsel and the buyer has not, you would generally just want the best drafter to draft at that point. And then the seller will prepare disclosure schedules to the purchase agreement where they will disclose certain facts being true, certain qualifications of the representation and warranties, or other information that would just make the purchase agreement itself too bulky. Now that's your purchase agreement. In addition to your purchase agreement, you have what are called ancillary transaction documents, which is basically all the rest. And so these are highly, highly customized based on the target company, the seller company, as well as the terms of the transaction. So I'm just going to give you a couple examples, but I can tell you we're doing one deal where it's the acquisition of a 5-branch franchise owned by 5 separate operating companies. And we're trying to determine whether that will be purchased in a single entity or 5 different entities plus a holding company. And that drastically changes the overall structure, whether it's an asset purchase from the 5 to a new 5 holding company or operating companies, or whether it's a stock sale or an equity purchase of each of the equity interests in the 5 operating company and putting that into a holding company. Very, very, very different implications, very different scope of work, very different cost structure from a legal perspective, because obviously if you have 5 different asset sales from 5 different companies, you ultimately have 5 different transactions. And then if you have the acquisition of the equity interest in 5 different operating companies, but you're able to flow it into one holdco, it's still 5 different acquisitions, but you can simplify it a lot more. You generally have a lot less documentation required for a stock or equity purchase than you do for an asset purchase. So on the asset purchase side of things, on either side of things, you may have a seller note whereby the seller provides some sort of financing in the transaction. And on either side of things, you may also have a relatedly pledge agreement or security agreement related to the seller note. On a purchase or sale or a purchase of an asset purchase or an equity purchase, you'll likely also have seller sort of engagement post-closing. This is typically an independent contractor or consulting agreement if it's an SBA deal. If it's not, it may be an employment agreement. Now, on an asset purchase, when you have the transfer of the business, you actually have to also transfer the employees of the business and the independent contractors of the business. So you actually have to have a resignation from the prior company and a offer to the new company. So you have offer letters or employment agreements to the new company. Now, when it's an equity purchase, there is no change in their employer relationship, but you may still have key employment agreements, or you may still have just a letter announcing the change of ownership to employees, giving them comfort that their salary and benefits will not change. So you may still have some sort of communication with employees, but it's a different legal structure from one to another. You're also going to have in both situations a non-competition and non-solicitation agreement or restrictive covenant agreement. With that said, you also may have that woven into either your purchase agreement itself, or you may have it woven into your employment or contractor relationship with the seller. So it just depends on how many sellers there are, whether they're all going to be restricted by the non-competition, non-solicitation, or restrictive covenant agreement. So those are kind of terms dependent on the target company and the terms itself. Next is leases or real estate. Is the real estate being purchased? Is it not? If the real estate is owned by the operating company, most of the time it's not, and it's being purchased, it's actually super simple because that change of ownership of the operating company will actually assume the ownership of the real estate. Most often it's more complex than that. Most often it's actually a separate purchase because you have a separate real estate holding company and you're going to transfer it into a real estate holding company the buyer owns, and then you're going to have the operating company pay rent to the real estate holding company, similar to probably an existing structure. So oftentimes the real estate, if you're purchasing it, has to be a separate transaction, but it's been rare and it has happened that we've seen it be a really super simple transaction because it's held by the operating company. In addition, if you have leases, you have to check for assignability provisions, change of control provisions. We have a whole episode on this that you can check out more on, where you have to see whether that lease can be assumed by the buyer, or you have to see whether that lease needs to be entered into as a new lease, which may be a result of underwriting requirements from the lender. So those are all things that are going to depend on the terms and conditions of the deal itself. Now, moving on, sometimes there's transition services agreements. This may be dependent on whether it's an asset purchase or a stock purchase. And those transition services agreements are generally going to depend on whether the transition services are different from the continued independent contractor relationship or consulting relationship with the seller. It's more if the business itself is like, let's say there's multiple connected companies and they have a company that does all the HR or back office or something like that. And before you independently as the buyer set those services up, you may have the seller that's retaining certain pieces of the business or business portfolios provide those services. Another element that may be true for either a stock purchase or an asset purchase is an escrow agreement. And this is simply whether escrow is within the deal structure. Now we start to get into some really different, let's go through everything else that's the same on the rest, and then I'll get back to the differences. So resolutions, you're always just going to need approvals of the different corporate structures. So whatever the target company and buyer company's corporate structure is, you're going to have approval requirements. So those are called resolutions. They may be unanimous consents. If it's a corporation, you'll have the stockholders as well as the directors. And then if you have an LLC, it might be of the members or maybe of a board, depends, all on the specific corporate governance documents. You'll also generally have secretary certificates and officer certificates from each party. Those are going to be dependent on the general structure of the deal, but generally you'll see those in all transactions, and certainly from an underwriting perspective, secretary certificates would be expected. Now, I think from there, it gets into everything that's specific. So when you're on an asset purchase, we'll just continue with the asset purchase side of things. You're going to need assignment and assumption agreements. This is going to be assigning and assuming contracts. If licenses or permits are assignable, you might also assume those. Sometimes you might have a separate contract for assignment of intellectual property. If not, you might subsume it into the assignment and assumption agreement that generally covers contracts. You would also have a bill of sale. That's one of the elements to transferring personal property. You would have the titles of vehicles, the deed of real estate, if there's pension plans, welfare benefit plans, assignments, or terminations, and related documents. And then you may also have regulatory authorizations and filings that may be on either side. So those are a couple of the different elements, but it's really hyper dependent on the company, target company itself, and what type of assets it has. Once we do a review of all the different types of assets that it has, then we'll be able to decide whether further documentation is required beyond those standard documents that you see in most asset purchases. Now, from a equity purchase, let's just say it's a corporation. In a corporation, and this is different if it's an LLC, you might have a stockholder representative agreement, which is where the stockholders, if there are more than one, authorize a certain representative to sign on their behalf an LOI or some of the initial documents. Sometimes you'll have it be for all of the documents, but you would still want to see an authorized consent of the transaction where at least everybody signs something authorizing it. This just helps it so that there's alignment on the equity holders and you don't have to negotiate with 10 people on every single piece. You can be having a conversation with one person and they're representing all of the owners. I forgot to mention this on the asset purchase, but also payoff letters. If there's any loans that are being paid off in connection with closing, those are going to be on both an equity purchase and an asset purchase. Third-party consents are for both as well, with lenders, inventory creditors, leasing agents, equity leases, material contracts with customers, suppliers, vendors. We talked about regulatory authorizations. Okay, for an equity purchase, you're also going to have resignation of officers and directors, which are generally your owners. Sometimes there's also officers and directors that are not the owners, but you're generally going to have resignations of officers and directors that are the owners, sometimes even more, to change the control of the business. You'll also have stock powers and stock certificates. In an LLC, this would be assignment of membership interests, and whether or not those membership interests are certificated would depend whether you would need certificates and powers for those. Those are just a couple things. Depends on the deal specifically, but you might also, if it's real estate is involved, you might have a FERPTA certificate. Likely, if there's a working capital adjustment, you'll also have working capital adjustment, working capital statements, estimated working capital statements, closing working capital statements. Let's see what else. You'll generally have good standing certificates of the parties required for closing. If there's any tax liens, tax lien waivers, or a entity status letter from the relevant tax authority. Generally, this is called a tax clearance certificate, but it is changed. The name of it is different from state to state. And then we have, all of the different transaction documents being delivered at closing, wire confirmations, flow of fund memorandum. Generally, the flow of funds memorandums are provided by the lender. If it's an equity purchase, you may also have amended and restated bylaws or amended and restated operating agreement of the company. So as you can see, a very basic deal. Everybody says, oh, there's no hair on it. It's really basic. It's really straightforward. What's the scope of work for this? And so they think it just takes this purchase agreement to transfer the business, when in fact it generally takes 12 to 15 plus transaction documents for a simple under $10 million deal. So just like to count them, because I don't think I've actually really counted them. You've got your purchase agreement, seller note, seller independent contractor agreement. That's not even including a pledge and security agreement related to seller note if required. Key employment agreements, non-competition, non-solicitation, something to do with the lease, whether it's an assignment and assumption or landlord consent. Resolutions of each party, secretary certificates of each party, officer certificates of each party. And that's a flow of fund memorandum, and that doesn't even include all of the potential elements based on terms, or also the potential based on whether it's a stock purchase or an asset purchase. So we're already at 13 different documents as a minimum. So as I said, generally looking at 12 to 15 minimum of transaction documents required for the transfer of the business. So it may surprise you, but these are actually everything that your lender will require for the transfer of the business. Now, if you're self-funding the business, can you get away with a little bit of a leaner transaction? Maybe, but if you're paying more than $1 million, why would you want to cut corners? I mean, if you're paying $200,000, like I don't just drop $200,000, and not want legal documentation around it, but all being legally valid and binding and effective. So, I mean, honestly, even if I was paying $50,000, I would want it legally documented correctly. So all a matter of risk and what you feel comfortable with, but ultimately those are the documents required to legally transfer the business. So do you need to work with a lawyer? I highly recommend it. This is not an area that you want to DIY it. You don't want to spend $10,000, $100,000, or $100 million trying to DIY it. Yes, there is a cost to working with an attorney. If you'd like a quote on that, you can schedule a consultation call with us at Dean Street Law. But ultimately, it will be more expensive to fix any issue than to do it right from the first place. That's always the case. It usually costs 10 times more at least to fix an issue than to do it right from the beginning. You get your value worth its weight in gold when you work with an attorney. Just from structuring an LOI, I've saved clients hundreds of thousands of dollars in structure, in capital stack, everything like that, in making mistakes. So working with an attorney not only is going to make sure you have your documentation, but they're also a team member who has an incredible amount of value to add to the conversation on structure and terms and the ability to negotiate something and get it to closing, because one of the worst things to do is pay for financial due diligence and try to pay $5,000 for a purchase agreement and then find that you paid all this money for the business, you've paid hundreds of thousands or millions of dollars for the business, and then it's not legally binding, or someone has an issue. Someone asked me, I was on a consultation call and someone said, I really want to do it myself. What are the real risks here? It's just the seller, they own it, there's no issues. And I was like, well, I mean, I can ask you a couple of questions. I can tell you what we could provide, and I would tell you the services and the scope of work and the pricing, and you can determine for yourself whether it's worthwhile or not. And in my first two questions, which is, does the seller own 100% of the business? And they said, no, he owns it with his wife that he's currently getting a divorce from. I said, okay, well, if you were just planning on getting the seller who you said is the sole seller of the business, because I said, who's the owner of the business? It's this person I've been talking to. And then my follow-up question is, do they own 100% of the business? They're like, oh, no, they own it with their wife. Okay, well, the wife has a claim to the business and can invalidate the whole sale of the business if you don't do it correctly and get her authorization on everything as well, and documentation, etc. You can only legally sell and transfer what you have the right to legally sell and transfer, which is one of the most fundamental aspects. If they tried to do this on ChatGPT or other AI and said, please just draft me a purchase agreement, this is the owner, without pulling in the nuances that actually the wife owns a percentage of it, and you should really do due diligence. You never take someone's word of who the actual owner is. You want to make sure you due diligence all of that, but you want to make sure that you are doing all of these due diligence aspects, documenting it correctly, and ultimately then you're able to properly transfer the business. Don't have to worry about it anymore, or at least until, the indemnification provisions close. And then make sure that the business you're buying is the business you think you're buying. I hope that was helpful. Please leave us a 5-star review, and I look forward to seeing you in the next episode of Dealmaking with Laura Difrancesco. Cheers and happy deal making. Thank you so much for joining us on this episode of the Dealmaking with Laura Difrancesco podcast. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please be sure to follow and subscribe to Dealmaking with Laura Difrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please leave a 5-star review. It would mean the world to us. And share this podcast with your network, friends, and colleagues. For more in-depth resources, be sure to visit our website, deanstreetlaw.com, where you can find articles, guides, and more information on our services. Don't forget to follow us on social media for the latest episodes, updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LMDFrancesco on X, and at Dean Street Law on Instagram. Join us on our next episode where we'll explore more deal-making insights. Cheers and happy deal-making.